Good morning, Mr. Slager. Good morning, everybody.
Morning.
Are you ready?
We are ready, Chairperson.
Okay, let's start.
Thank you.
Dr. Nteta, good morning to you.
Good morning, sir.
The oath you took yesterday continues to apply today. You understand that?
Yes, I understand that.
Okay, all right.
Thank you, Chairperson.
Proceed.
Yes. Chairperson, Dr. Nteta was giving her apology from yesterday. She can't see us, but we can see her. So she's unable to see whether we have stopped talking. So sometimes there was an overlap between us talking and her talking.
Oh, why is that?
I don't know, Chair. I don't know why.
Well, the technicians, have you asked the technicians?
I've asked the Reverend.
Why is that? Because we have never had that situation. Let the Reverend tell you what's going on.
Chair, the Reverend says the witnesses can only see you if they have the laptop in front of you. But once they've disconnected your laptop, then the witnesses can't see you.
They can only see me if what?
If a laptop for you is connected to the meeting link.
And why is it not connected? Because it's always connected on other occasions.
Yeah. Should we address it at tea time, Chairperson? What the Reverend is explaining is the laptop was once there, and on the Chairperson's request it was removed, but it could probably be connected somewhere else, I don't know.
Yeah, no, I'm going to adjourn and to get this sorted out. What should have been done, what should not have happened, is that it should not have been removed without me being told that its removal would have this effect.
Yeah.
Nobody said if it was removed, this would be the consequence. And if I had been told that that is what would happen, I would have said it should be kept.
Yes.
So nobody said this is what would happen. How long can it take for it to be connected? Because I don't like this idea that the witness can't see us.
Yes. He's indicating about 10 minutes, Chair.
Yeah, we are going to adjourn. That must be sorted out quickly so that we can then continue.
Thank you, Chair.
We adjourn.
Should I mute?
Yeah, you're welcome to mute in the
Thank you.
Yes.
Hello,
Good morning, Dr. Nteta.
morning.
Yes, can you see me?
I cannot see you. I can see a computer screen with headphones on it. And on that computer screen, I then can see the room. It's being, the computer screen is being lifted.
Okay, yeah, we're trying to sort that out. David, your two guys at the van must put this position. There you go. Can you see the screen, ma'am?
I see the computer screen, yes.
Yes, that's what is going to happen. David, ask your van guys to cue this camera.
Hello? Oh, there's another Ayanda. Okay. I can see a gentleman on a green chair with the cell phone on.
Yes, that's the chairperson's chair, ma'am. That's what you're going to see. I'm the acting chairperson at the moment. That's where the chairperson will be seated. David,
Okay.
David, can you ask the guys to just test with the evidence leader as well, so that what you can see? Essie, can you please speak from your mic?
Yes, 1, 2, 3. Testing, mic 1, 2, 3.
Can you see the evidence leader, ma'am?
Yes, I can. There's a glare behind him. I don't see him well, but I can see his silhouette.
Okay, ma'am, that's fine. At least if you can see the chairperson and the evidence leader, which is much better now.
No, she
Okay.
can't see.
Okay, ma'am, thank you so much. David, are we ready?
Yeah, that's better.
Please tell her she's going to see her son.
Dr. Nteta, at some point you'll be able to
Yes.
see yourself as we go along. Please don't be alarmed. It's how the technicians have sorted that out.
Okay, no problem. I did see myself at some point.
Yes, when you speak, you'll see yourself. Yes.
Okay. All right. That's fine.
Okay. Solihle, you're the one must move. Are we ready now, David?
I'm assuming you can hear me, so thank you very much, everybody. It does make it a bit easier for me.
Oh, okay, ma'am, that's fine. We'll just finally touch up and then we'll be ready. Can you see the chairperson's chair now, the green chair?
Yes, I can.
Okay, thank you. And the evidence leader?
No, now I'm seeing like glare of a screen on a screen.
There's the
Now I
evidence
see
leader.
him.
Okay, that's
Yes.
fine. Thank you so much.
As I said, he's not very clear
We'll sort that out.
because
ma'am.
there's a glare behind him.
Don't worry, we're trying to sort that out quickly. Yeah, that's fine. Thank you. Colleagues, 5, 4, 3, 2, 1, ready? Thank you. That's fine. That's okay. Yeah. Tembani. It's fine. It's okay. To me. Don't worry about the level, as long as you can see the chairperson. To me. To me. Ready. Thank you.
can Dr. Nteta see us now?
She can see us, Chair.
Dr. Nteta, can you see me?
Yes, I can see you.
And the evidence leader, you can see him as well?
I think I will see him now I can see him.
Or
Yes.
when he speaks?
Yes.
Okay, all right. Now, Reverend Stumela, is this light the way it should be? Okay. You're putting me in the dark, in darkness. I think maybe he's not happy that I said they must make sure the witness sees us. So he's retaliating by putting me in darkness.
There's vengeance.
Okay, all right. Okay, all right. Let's proceed then.
Thank you, Chairperson. Dr. Nteta, yesterday we were about to go into your second meeting with Mr. Tony Gupta.
I'm sorry, Mr. Seleka, before we proceed,
Yes, Chair.
can we have a common understanding of how much time you need to finish with her evidence?
Oh, yes.
What's your assessment?
Let me see, Chair.
I think yesterday you may have gone to just before half of her statement, I'm not sure.
Yes.
So
Yes.
I was wondering, I was having in mind that you might need 1.5 hours or so, or at most 2 hours.
Let's try 2 hours, Chairperson.
Yeah.
Let's try
Okay,
2
but
hours.
I think just up the pace as you ask questions,
Yes.
so that we try and get as much done as possible within the time.
Thank you, Chair.
Okay, all right.
Yes, Dr. Nteta, we're about to go into your second meeting with Mr. Tony Gupta. Just before I do that, just one thing I need to clear with you, and that's going back to the reasons why you left Eskom. We have seen from Mr. Jabu Mabuza, the former, was it a chairperson or a CEO of Eskom? Chairperson in 2018?
Chairperson.
Yes. That his evidence was to the effect that you resigned while there was a disciplinary action pending against you. Could you comment on that quickly?
Okay. And I will take the liberty of relating from the beginning of my affidavit. And I indicated in my affidavit that I had mainly 2 reasons for leaving Eskom. The first reason was to continue with my studies. And the second reason was really because I felt that the incoming board and executives at the time, I felt, and it is my opinion, that the continued undue interest in various transactions within the primary energy space, this trend was going to continue. So having been requested to provide a submission for a transaction, another transaction, which was adjudicated in the evening of a Friday, and some other discussions that I did have with some executives, I felt that I wanted to leave Eskom because I did not want to continue to endure what was unpleasant. And at the time, my direct line manager was the CFO. I had a conversation with the CFO in March of that year, indicating to the CFO that I would like to exit my employment at Eskom, And it was, indicating what my notice period would be and wanting to have a cordial discussion with him, of which we did, in terms of when would I like to leave. He asked me when am I thinking about leaving, etc. If I'm elaborating too much, you will interrupt me. So.
Okay. I will.
So at that point, I said indicated, well, I will then come through with a letter of resignation at the end of the month, but I didn't want to have a discussion with him prior to that. It was around about the middle of the month. I was later, probably the next week, I think it was, I was then called in by the Group Executive for Generation. At this point, I want to note that I did not report to the Group Executive for Generation.
I'm sorry,
And
I'm
they
sorry,
then
Dr.
handed
Nteta.
me.
I'm sorry, Dr. Nteta. Just tell us who the CFO was. You have just told us you had a discussion with the CFO. Tell us who he or she was.
Mr. Kasim,
Mr.
Kasim, what is,
Is it Caleb Kasim? Kalib
Yeah.
Kasim.
Mr.
Caleb, sorry, Caleb Kasim.
Mr. Khalib Kasim.
Yes, I think his surname is Kasim, but Caleb.
Okay, all right. Okay, continue. It's just important as you talk about positions to tell us who was occupying that position at that time. So
It was Caleb.
Yeah,
Yes.
okay, all right. Continue.
Okay. It was Caleb. I then had later I was called in by the acting group executive for Generation, which was Mr. Willie Majola. And for a meeting, I entered the meeting and he had somebody from labor, from HR there. And at that point, they handed me a suspension letter. I indicated to Mr. Majola that I have, in the previous weeks, had a discussion with my immediate manager, indicating that I did want to resign. And I then asked the HR person as well, so what would be the process going forward with this? At the time, they seemed surprised, I must say. And then they said, well, we are giving you this and you are asked to vacate the premises with immediate effect. Of which I did. I vacated the premises with immediate effect. So that is the letter of suspension. Having done that, I then wrote to, a few days later, I think it was, I wrote to my immediate manager, which is Mr. Caleb, the CFO, and I indicated to him that, our discussion, and I then indicated to him that I've subsequently from his colleague received a letter of suspension. However, in light of our discussion that we had, I would like to still continue the process in terms of serving my notice, even though I was asked to leave with immediate effect from the suspension. And that is that letter is actually is documented, and I'm sure they have it. I can provide a copy. And so I then served my notice in terms of the Eskom. It was a month's notice that I was required to do. I think probably 2 weeks in that notice, they indicated to me that they would be scheduling, I think it was a disciplinary. Once again, that was not coming from my immediate manager, it was coming from his colleague. And my limited understanding of HR is that it is your immediate manager who disciplines you and not colleagues within the organization. And then I received documentation from my manager in terms of resignation, the normal documentation, and they engaged with me, HR engaged with me. And then I had my last day at Eskom at the 30th of April, 2018.
Yeah. So
the reasons for the suspension, sorry?
So one, you had a discussion with your immediate manager where you indicated that you intended resigning, and before you could submit your letter of resignation, you were served with a suspension letter. Is that sequence correct?
Yes. I
After-
had agreed with my manager. Sorry, sir.
After you had been served with a letter of suspension, you immediately left Eskom to comply with the suspension letter. Is that correct?
Correct.
How long after you had received your suspension letter did you submit your letter of resignation? About a week?
I'm going to say probably about a week.
Yeah, more or
so.
less, more or less. Okay.
More or less, yeah.
Yeah, okay, all right. And then they told you about scheduling a disciplinary hearing, but that never happened because then your resignation took effect. Is that correct?
Yes, so during that, the period of my notice, about 2-3 weeks into that, they sent me the letter.
Yes. And was the disciplinary hearing scheduled for a date within your notice period or outside of the notice period?
They didn't give a date.
As yet?
It was more, yeah, they didn't give a date or a venue. In fact, I think it was more of just stating what the
charges.
issues are, because after the 4-day suspension, they need to then tell you, you know, what
the charges are.
what the charges are.
Oh,
So
so
let me rather say it was more like charges.
they were telling you what the charges were going to be.
Yes.
Okay, all right. But then your resignation took effect before there could be a hearing.
Yes, before they came back to me.
Yes. You said you served your notice. Does that mean that you came back and actually worked, or you served your notice on suspension?
I served my notice on suspension. I came in at the end of my notice at the request of the then chairman to attend to some in the other investigations that were ongoing, to provide evidence for that.
Okay, all right. Mr. Selega?
So yeah.
Okay, Mr. Selega?
Did those investigations pertain to your conduct? Where you were called in to give aid?
Which ones?
The ones you say you were called in to give?
No, it was to do with it was actually, some of it was Tegeta related matters, but it was to do coal contracts, not specifically my
Your conduct?
conduct.
I see.
Yeah.
Okay. Did the charges against you, if you can recall, did they relate to the Tegeta transaction?
So the charge is correct. They related to the Tegeta transaction. It was quite specifically related to, in my role as a senior general manager, primary energy, there was a temporary relief that I provided to Optimum Stroke Tegeta for coal coming through. And it was relief in terms of the qualities, for a set period. So that is what they were. And then they indicated that there's a breakdown of trust.
Yeah. I saw that you deal with that in your affidavit, the temporary reliefs that have been given to Tegeta.
Yes,
Yeah.
yes.
Did they indicate what the factual basis was of the allegation that there was a breakdown of trust? In other words, did they say there's a breakdown of trust because you did A, B, C, D, E, and that's why there's a breakdown of trust? Did they indicate that?
So They indicated that there was a breakdown of trust based on the providing of the temporary relief.
So that was the sole basis, as you understood it.
Yes, as I recall, I'm actually trying to see if I can find the actual letter, because I'm feeling that I may have
You might have
forgotten
not recall
something.
everything.
But yes, I might not recollect fully, but it was based on the temporary relief, what I do recall is that they also indicated a breakdown of trust.
Yes, okay. Well, if Mr. Selege have got the letter somewhere in their bundles, or he indicates they don't have. Yeah. Okay, all right. So, if and when you have found it, you will let us know. In the meantime, you may continue, Mr.
Yes.
Selege.
Thank you, Chair.
Sorry, Advocate Seleka, if I may just interrupt you.
Yes.
Do you want me to look for it now and send it during my time with you, or do you want me to get it later? I can get it at tea time if there's going to be
Maybe
tea.
she can get it through during a break or something.
I think so too.
How much time
Not
do you
a
think you
problem.
need to get it, or you are not sure?
No, I have it. It's just looking on my computer, but I don't want to do that while
Yes, that's
providing
fine.
evidence.
Okay,
Yeah.
okay, we'll do it.
So it won't take long.
We'll
I don't
do it during
anticipate.
some break.
Yes.
Okay,
Thank you,
let's continue.
Thank you, Chair. The aspect, Ms. Dr. Nteta, regarding the temporary relief afforded to Tegeta, it's of importance to some extent in regard to the Tegeta issues. And maybe you could explain to the chairperson briefly on this temporary relief. What does it entail? Because you say it related to, or as I understand it, it related to the quality and the quantity, which is the volume of coal. Correct?
Yes. So with regards to the temporary relief, the temporary relief that I signed was to do with coal quality and in terms of the volumes. So and which are operational issues. So the temporary relief that I signed is firstly based on a previous temporary relief that was provided to them, and it was for a limited period. What tends to happen in terms of mining operations is that as you mining through certain areas, you might get to an area where you would experience what they would call a dike or some aspects that affect the quality and the volumes that you are able to provide through. So what we allow for our suppliers is that in that particular aspect, they would advise us that due to technical issues, we're not able to provide you with the volumes, and sometimes it's volumes and quality, sometimes it's both, etc. And then we will then say for that period, whilst you're mining through that dike, then you can then provide us with either a reduced quantities if it's affecting your operations, or we would then look in terms of the qualities if they would be we will still be able to use them. You can then reduce that quality. It's normally one particular aspect of the quality or two. They mine through that particular area. Once they've mined through that particular area, then they would then revert back to the contractual volumes and qualities, etc.
Okay.
So that relief was for 3 months to allow them to address their operational issues that they have, which is what we do it's just how we would manage contracts because of the robustness of mining operations.
Yes. No, that's all right, because what I'm trying to understand from you in regard to the relief is not so much the reasons, but what the relief entails. So that relief, if I understand you correctly, when you give a relief in respect of quality, that means you will then accept as Eskom coal that does not meet the required quality.
Yes. So, and why we call it it's relief in terms of that particular quality.
Yeah.
Or the volume as well.
Or the
It can be
volume.
sometimes the volume.
Yeah, so if
Yes.
they are supposed to provide, by way of example, 10,000 tons of coal is it per month or per week? You would compromise that and say, okay, I will accept 5,000 volumes of coal. Is that what the relief means?
Yes.
Yeah.
Yes, that type of relief.
Yeah.
Just
For
raise
a
your
period.
Just raise your voice,
My
Mr.
voice.
Selega.
Thank you, Chair. And for the purposes of this aspect, you deal with that in your affidavit on page 69. Chairperson, that's Eskom Bundle 14.
Just before that, Dr. Nteta, when you grant the kind of relief that you are talking about to a service provider, is the effect of the relief you grant to them, namely, is it that you condone what would otherwise have been a breach of the contract?
Yes.
So you effectively say, for the reasons that you have given us, we understand that you are going to provide us with coal that doesn't meet the contractual standards, either in terms of quality or in terms of volumes or both, for this following period, and we accept that. That's the effect of the relief.
Correct.
Okay, all right.
Yes. Thank you, Chair. So, insofar as quality is concerned, Dr. Nteta, we understand that these coal contracts have penalties, clauses in them, that if you fail to provide coal of a specific quality, penalties will be imposed. Correct?
Correct.
In this case, I referred you to the page number, page 69 of Eskom Bundle 14, Chairperson, paragraph 7.4. Or we can actually start at 7.3. You are there, Dr. Nteta? Or you are moving?
Yes, I am.
To there. So that paragraph 7.3 says, during April 2016, the ownership of OCM changed from Glencore to Tegeta as per sale of shares agreement. So April 2016. Subsequent to the cooperation agreement being signed, Eskom issued a temporary relief agreement to OCM on 20 December 2016 for the period of 1 September 2016 until 31 July 2017. So that relief on 20 December 2016 is in fact issued to Tegeta as the new owner of the mine.
Yes. Yes, I don't know who it was issued to, but yes.
Yeah, because Tegeta is not, well, if you read that with your paragraph 7.3, because ownership changes hands, you say April, and Glencore is no longer the owner, Tegeta is the owner, and on 20 December 2016, only Tegeta would be the owner at this stage. Did you issue that relief?
So the first relief I did not issue. The first relief, I think, was, so the relief that you're referring to in this statement, I did not issue.
Yes, okay.
It was issued by my predecessor.
Okay. Now, I'm taking you down.
I'm sorry.
Yes.
Did you say there is a first relief that you did not issue? You issued a later one?
Yes, so the relief that Advocate Selega is referring to in this paragraph 7.4
Yeah.
is a relief that I did not issue. It was issued by my predecessor.
And who was your predecessor?
That relief was issued by Mr. Edwin Mabelane.
Oh, okay.
Yes, Chair, I see annexure
Yes, okay.
AKL08, AKLN08, which is on page 187.
Please speak up, Mr. Selega.
That's annexure AKLN08, which is on page 187.
Yes, okay.
Yeah. Indeed, it's a relief issued by Mr. Edwin Mabelane, but he's the Chief Procurement Officer at the time, Dr. Nteta, 20 December 2016.
Yes, at some point within Eskom, Mr. Mabelane played the role of both Chief Procurement Officer and Senior General Manager for Primary Energy. So it's possible that during that period, he had both portfolios.
Yeah. And then there were subsequent reliefs granted to Tigeta, you say, further in your affidavit.
Yes, that's the one that I'm referring to that is linked to the suspension.
Just tell me this temporary relief that you granted and that Mr. Edwin Mabelane also granted. The power to grant that relief, was it contained in the coal agreement or was it provided for in some other instrument within Eskom? What was the source of that power?
So the power, and I'm going to give you my interpretation of it. The power to grant that relief lies in the coal operations, as it is an operational issue that we would have to look at and look at in terms of the merits.
Am I correct to understand you to say, as far as you know, it was not in the coal agreement?
So in terms of the coal agreement, that particular agreement is linked to mine. I would understand that would be part of the coal agreement in terms of coal management, the contract management, and contract management, which is indicated in the agreement, would then deal with issues of operations and how do you manage it. Because the department within primary energy that is called coal operations is delegated to manage, and they would look at issues of volumes within the contract, moving them up, down, if there are issues in terms of ramping up qualities, etc., as part of their function.
Okay, let's take this step by step. Are you saying that your understanding was that the coal agreement gave that power to those to whom the responsibility to manage the contract was given? Is that what you are saying? That was your understanding?
Correct.
In other words, you are saying the power to manage the contract, you understood to include the power to grant this kind of relief.
Correct.
Yes. Is there anything else other than the contract that you understood to be the source of this power, or is it only the contract?
It would be the contract. It would also be the delegations that are granted to the contracts management department.
Yes. And those delegations, did you understand them to have an express provision that talks about temporary relief, or not necessarily anything express, but you understood them to include the power to grant this relief?
I understood it that they would be, understood it as such, sir, that those powers that are delegated relate to being able to provide a temporary relief.
But would I be correct in understanding you to say, you are not saying if we go to the delegation, we will find an express wording that said you could, you had this power, but there might be no express wording, but your understanding was nevertheless that it was part of what was delegated, the power delegated in terms of delegations?
So my understanding is that the delegation that is provided to primary energy is to, one is to negotiate and conclude contracts, as well as to manage the execution of those contracts, which includes quality, price, and elements like that. So that is my understanding of the delegation provided to primary energy.
Other than the granting this temporary relief to Ntetha on this occasion, had you had other occasions where you granted this type of relief to another supplier or other suppliers?
Myself personally, no, but within the primary energy division, we would, so noting at the time that I was now the Senior General Manager for Primary Energy, which oversaw various departments. Before I used to only look in terms of on the sourcing side of things. So I would not have been involved with that personally before. However, within the coal operations department, they on a daily basis would manage and look in terms of those particular aspects. So I was aware that that is their role. Hence the motivation to provide this temporary relief came from the coal operations department.
So is the position that even though you might not yourself have had other occasions where you granted this type of relief to a supplier, you were aware that this type of relief had been granted to other suppliers by the relevant authorities within Eskom in the past?
Yes, I understood it as the practice. Yes,
Yeah.
not myself personally, but correct.
Yeah, okay. Mr. Siliga?
Yes, thank you, Chair. And that obviously will be surprising if you were to be charged for doing something that is the practice at Eskom.
Correct.
So then Eskom seems to have had a different view about whether or not you were authorized to do or offer the temporary relief.
Correct, which is why they would have charged me.
Yeah.
Did you understand the basis of the charges against you, or the charge against you, to be the mere fact that you granted the relief? Or did you understand the basis of the charge against you, or charges against you, not to be the principle of granting relief, but the circumstances under which you granted the relief, that maybe as far as Eskom was concerned, you granted relief in circumstances where you knew it should not be granted? Which one of these two was your understanding of the basis of the charge?
Okay. My understanding, and I did not get any engagement, if I can put it that way, with my principals on it. So I'm reading, my understanding is based on the letter that I received. My understanding is that Eskom believed that I did not have the delegation to grant that relief.
Okay, all right. But as far as you are concerned, obviously you reflected on the charge and you have had time to think about it. As far as you are concerned, you did have the delegation.
As far as I'm concerned, I did have the delegation. It had been done before. There was a cooperation agreement with Glencore for 3 years based on the same principles, which was signed by my predecessors as well.
Yes, okay, all right. Mr. Selega.
Thank you, Chair. Dr. Nteta, you do refer to a cooperation agreement in paragraph 7.4 of the affidavit. You say,
Yes.
you actually also refer to it in paragraph 7.2, the cooperation agreement with OCM. But the cooperation agreement of 2014 was terminated by Mr. Brown Molefe after his secondment to Eskom in May or June 2015. You are aware of that?
Yes.
Yeah. Now, after that, there was no cooperation agreement between Eskom and Optimum. So which cooperation?
Yes.
Sorry. Which cooperation agreement are you referring to in paragraph 7.2? 7.4, I beg your pardon.
So the cooperation agreement in 7.4 would be the temporary, the first temporary, no, the cooperation agreement is the one that you are referring to in terms of the one that was terminated by Mr. Molefe.
Oh, so is it my understanding that you thought that it was still the same agreement in place in 2016?
No, if I may.
Yes.
So my thought process at the time and in also providing this affidavit was to provide I refer to the cooperation agreement because in that cooperation agreement that was terminated by Mr. Molefe,
Yes.
it spoke to issues of quality and it spoke to issues of volumes as well, where there was a relief provided in terms of that agreement for those two aspects, right? So when I was then providing this particular narrative, I was referring to it based on the reasons or the information that is in that agreement. The temporary relief, the first one is the one that was signed by Mr. Mabelani, which was for, I think it's 6 months or so. I stand to be correct, more than that. I stand to be corrected. So that is a second document that I'm referring to. And then there's a third one, the one for which I did sign.
Yes, okay. So what I was just saying to you is, by this time, there is no cooperation agreement between Eskom and Tigeta that we are aware of. So what you see is a temporary.
Correct.
Yeah, sorry. I should give you a chance to respond, yes. What we however see on the 20th of December, 2016, when
I'm sorry, Mr. Selega, I'm sorry to interrupt you.
Yes.
You did earlier on mention on which page I will find this annexure AKL N08. I want to go there as you ask those questions.
page 187.
Is it 187?
Yes, Chair.
Okay, all right. Then you may continue. I'm sorry I interrupted you.
Not a problem, Chair. So what we see then, Dr. Nteta, on 20 December 2016, is the temporary relief being granted to Tegeta? On paragraph 7.4, and the temporary relief applies retrospectively from the 1st of September. You see that?
Correct?
Yes. So this. So it will apply retrospectively to over 4 months before it is issued. And then it applies from December, January to July 2017 going forward. So that's adding 7 months into it. Because
Correct.
it ends on the 31st of July 2017. So that's more than 6 months.
Correct. I did say approximately. Yes.
It's in 2017 alone it's 7 months. In 2016 alone it's 5 months. 4 or 5 months. So that's what, some 10 months there. But I want to ask you this in relation to this, because, well, it doesn't end there because you also give the temporary relief on the next page. You give it on the 18th of August 2017. You give it for the period 1
Correct.
August. Thank you. You give it for the period 1 August 2017. This is now immediately after the 31st of July 2017. 1 August 2017 to 31st October 2017. Correct?
Correct.
Now let's try to understand this. I heard you mention that the motivation for temporary relief would come from the Coal Operations Department.
Correct.
So there's the Coal Operations Department of Eskom.
Correct.
Would the supplier itself make an approach to Eskom to ask for temporary relief?
Correct.
And they would give reasons for that request.
Correct.
And in this case, you were also given reasons in order for you to grant temporary relief.
From our core operations department, yes.
Okay, so you didn't receive the reasons directly from the supplier.
No, I received them from the coal operations.
So
Did coal operations say we received a request from the supplier for temporary relief or for the extension of the existing temporary relief? And these are the reasons they have given. We support their request for the reasons that they give, or here are our reasons for supporting the request. Did they say anything along those lines?
So, yes. So the coal operations department at Eskom manages the coal contracts. So they on a daily basis engage with the supplier in terms of the running of the operations. So they would receive the request from the supplier. They would also have been, they would understand the operations of the mine because their job is to manage in terms of those particular elements. So it would have been an engagement from them. They then provided me a memo supporting, as you've indicated, sir, the reasons for the temporary relief extension.
Okay. Mr. Selega?
thank you, Chair. So the picture that emerges is like this, and you can comment on this. After Tegeta took over Optimum Mine, which is around April 2016, as you say in the affidavit. Tegeta, a couple of months later, is granted temporary relief with effect from the 1st of September 2016. The temporary relief applies to the quality of coal and the volume of coal, correct?
Yes.
That applied for 10 months until 31st July 2017. It's a period of 10 months from 1 September to 31 July. Immediately thereafter, you also issued a temporary relief for 3 months, from 1 August 2017 to October 2017. In total, it's 13 months. In October, and we know from the evidence that in February 2018, Tegeta goes into business rescue. February 2018. You know that?
Yes, February 2018.
Yes.
Okay.
Mr. Selega, on what page do I find Dr. Nteta's temporary relief to Tegeta?
It's the next page, Chairperson.
After the earlier other one?
Yes, correct, 188,
Oh, okay, thank you.
the next page.
You may continue.
Thank you, Chair. So that business rescue Tegeta goes into after the temporary relief is 3 months thereafter, 3 months after the temporary relief.
Well, before you proceed, Mr. Selega, can I ask this question, Dr. Nteta?
Yes.
I see that your letter to Mr. George van der Merwe, COO of Optimum Coal Holdings, where you granted the temporary relief, just like the one that had been done by Mr. Edwin Mabelane previously. Although it allows Tegeta to deviate from its contractual obligations, there seems nothing said on both occasions about how the price of the coal would be affected by this, insofar as, for example, quality is concerned. I would imagine that if you are going to give me grade A of coal, I'm going to pay a price that's appropriate for grade A. If you are now going to give me grade B in terms of quality, I can't be paying you for grade A. But I don't see anything in the letters that deals with that. Was that dealt with elsewhere, or is there some explanation for why there seems to be nothing dealing with it?
Okay. If I may be allowed an indulgence to talk a little bit about the contract. The contract, as it was quite an old contract, was signed, it was made on a rand per ton basis for coal within a certain coal quality. So the contract then talks to if, for example, you do not meet your obligations in terms of a certain range, a certain volume, etc., then that's when it then begins to affect the price. So, and I'm going to provide the narrative to also try and answer Mr. Advocate Silika. Apologies. So the temporary relief, which you talk to in terms of is a 10 months period, the issues that they had in terms of the mine continued from even the temporary relief, the cooperation agreement, which in fact was a temporary relief signed previously, so which was for 3 years. So those issues continued. Now, the temporary relief that I then granted to them spoke to the volume and the qualities for a prescribed period. However, they needed to ensure that they have done certain things. At the end of that period of the temporary relief, which I think it was around about October, in November, I then instructed the department to institute the penalties because they did not meet for the terms that I had for those 3 months, their obligation. They did not meet those obligations. So in November of 2017, we then instituted the penalties, and that resulted in us actually receiving coal for them for free. So from November, and then they ceased to supply because they indicated that they are unable to supply us anymore. And that is then also what then led to them, I would say, going into business rescue. So the financial aspects were then attended to within those mechanisms, and that is what allowed me to be able to institute those penalties.
Okay, I take it that your answer means that as a matter of principle, you accept that if they were going to provide coal of a lower quality, that should affect the price. But you are saying that although in the letter you did not address that, you say there was a mechanism in terms of which it could be addressed. Is that correct?
Within the overall contract.
Yes. But
So the contract had penalties, etc.
yes. But the idea of temporary relief, is it not in the idea of enforcing penalties for the provision to Eskom of coal that has been supplied, of coal of a lower quality, for example, that has been supplied to Eskom during a period where Eskom has provided temporary relief to the supplier? That notion seems to be inconsistent with with the nature of temporary relief. You remember earlier on I asked you whether granting temporary relief effectively meant you were condoning a breach or breaches of the contract, and you said yes. You remember that?
Yes.
Yes. So what I'm raising is that the idea that Eskom could later on impose penalties on a supplier for supplying coal that is of a lower quality than the coal provided for in the coal agreement seems to me to be inconsistent with the whole notion of granting temporary relief. Because as I understand your evidence, granting temporary relief is actually giving permission to the supplier to act in breach of the agreement because of the reasons given by the supplier, which you as Eskom found to be sound. You understand what I mean?
Yes, sir.
So what do you say to the proposition that when you grant temporary relief, you can't be at the same time contemplating that you will impose penalties on the supplier later on for providing you with coal of a lower quality than that specified in the agreement? It can't be. You can't be contemplating both.
Yes, sir.
You accept?
I accept, and I will agree with you that in terms of our negotiations with suppliers, they agree with your sentiment that you cannot allow me, you cannot say that I can provide you with a relief in some form, and then later on, then you then penalize me.
Yes.
Now, the rationale, and I will speak from Eskom's perspective. Most of the times when we provide temporary relief, not most of the time, but a lot of the times, it's for the quality and for the volume. The quality, it is and I'm going to say this, and Eskom will have to deal with the suppliers coming to them, in the sense that, so the quality that reduction that they have, in essence, is acceptable to us, to Eskom. It's within a range that has the potential to be acceptable. Whether it means that we move it to another power station or the boilers can then be adjusted to receive that coal. Because one of the big issues that we have is the security of coal supply, we would rather say that we will receive the quality that we can burn for a period, but we do want the volumes. So oftentimes when we provide you with the supplier with a temporary relief, it will say that for this period, and because we look in monthly volumes, instead of providing us with 10,000 tons, you can provide us with 8,000 tons. However, on the end of relief, you must go back to your volumes that you require. The contracts also allow us to catch up those volumes. So sometimes we can then say at the end of that, give us more volumes. And that is because we are looking to secure the volume of the coal. So in your analysis, you're correct that the suppliers do feel that you can't say it is fine and then you later want you later want the coal, but we need to secure coal.
You see, as far as you or Eskom may provide temporary relief in respect of volumes, I don't have any problem about that as far as the price is concerned, because I take it that you will only pay for 8,000 if they 8,000 tons of coal. If they provide 8,000, you won't pay for 10,000. But when it comes to the quality, where you grant temporary relief in regard to quality, that's where my concern is. Namely, in terms of the coal agreement, you would have imposed an obligation on Tegeta to supply coal of grade A quality, and maybe for a certain period they did that, and your obligation is to pay a price that is appropriate for grade A quality of coal. After some months, they say to you, please grant us some temporary relief. We can't grant you grade A coal for the next 10 months for the following reasons, which you as Eskom find acceptable. And I'm saying that when you then grant a relief to say they can give you grade B, you should be saying we will adjust the price as well. We can't be paying you for grade A coal for for the next 10 months when you will be providing us with grade B coal. That's what I'm raising, because I don't see it addressed in the letter. I would have expected it to be addressed. Why was it not addressed?
It is not addressed because it is addressed in the overall of the contract. And when you talk about an A-grade coal is a band. So when we put in, if, for example, if a supplier came and said, we normally give you A-grade coal, which is a band from a CV, I'm just going to give an example of 26 CV to 30 CV, if I give that an example. The grade B is maybe a 25 CV. Jumping between a band is significant, but within the band, it is acceptable because we are able to adjust in terms of our operations. And the implication is smaller. So we would then accept it. The contract then addresses those various mechanisms in terms of how we would accept this particular coal to come through. I also gave an example is that there are various aspects that when you look at the coal quality. So you might have an issue of sulfur that we say that we will accept, Eskom says they will accept up to 1%. And the supplier then says, can you provide us with temporary relief on the quality of the sulfur for 1.1 or 1.2? And we've looked at in terms of the significance, and then we would make a decision in terms of that. So it is not as clear to be able to then say X, and we try and cater for it within the contracts.
Are you saying the letter might not deal with that, namely the adjustment of the price, but the contract would have had a provision, or did have a provision, that effectively said, if the supplier provides coal of a lower quality than grade A, then this is how the price will be adjusted. Is that what you are saying?
Yes, so the contracts in general would do that. And also as we've moved further, a lot of the contracts are now based on a rand per gigajoule, which talks to the on energy content. So the later contracts that I was involved in, then we would then, it talks to that particular mechanism.
And this particular contract, do you remember whether it had a provision for the adjustment of the price in the event of the supplier providing coal of a lower quality?
So this particular contract, if my memory serves me correctly, has quite an extensive penalty calculation and regime that talks to elements in terms of the type of qualities, the kind of volumes, etc. And there are some calculations that are there.
Yes, but provisions relating to penalties would not apply, I would imagine, based on what you and I have discussed earlier on, namely, where you grant temporary relief to a supplier of coal, you can't at the same time be contemplating that you will impose penalties against the supplier, because during the period of the temporary relief, the supplier provided coal of a lower quality. You can't be contemplating that. So what I'm looking for is whether you are saying, if we go to the contract in this case, we will find provisions that say, in effect, where Eskom provides temporary relief, this is how the price will be adjusted. Or where it says, in the case of the supplier providing coal that is of a lower quality than stipulated in the contract, this is how the price will be adjusted. That is now separate from the penalties, because the penalties won't apply if you grant temporary relief. Are we going to find a provision that says that, as far as you remember?
As far as I remember, the contract doesn't talk about the issues of temporary relief, but it would talk to the issues in terms of how you manage the contract. I do want to say that I don't want to start delving into the details of this particular contract, because I have not looked at it recently. But my understanding would be that it would then deal in terms of the mechanisms of it, of the management of it.
Yes. Well, part of the reason why,
Yes, sir.
part of the reason why one is looking at some of these things is because there is an allegation that before the change of ownership, Eskom was very hard on OCM. They, for a long time, were complaining that they were operating under a contract that brought a lot of hardship on them, and wanted Eskom to accommodate their situation in various ways. And Eskom, after Mr. Brian Molefe had arrived, took a very hard line against them. But once there was a change of ownership and Ntetha was involved, the attitude, Eskom's attitude, was very favorable to them. There was inconsistency if you look at how Glencoe was treated and how Ntetha was treated. So that's part of the reason why we are looking at this. Here is a situation where Mr. Mabelane grants them temporary relief for 10 months or 11 months, I'm not sure, and then you also come and you grant them. And when I look at the letter, it doesn't say anything about adjusting the price. It seems on the face of it that although the quality of the coal is lowered that will be provided, the price remains the price for grade A coal. That's why I'm trying to establish. But I think from what you have said, it seems that one, you accept that the letter granting them relief, both your one and Mr. Mabelane's one, doesn't deal with that. That's point one. Point two, I think you also say, as far as you can recall, and you have said that you would need to look at the agreement because you haven't looked at it recently, but as far as you can recall, the agreement did also not deal with the adjustment of the price during the period where temporary relief has been granted. It had provisions about penalties, and you and I agree that penalties can't be applicable for a situation where temporary relief has been granted. Is my summary of your evidence a fair summary?
Yes, I would like to add, if I may, sir.
Yes.
With regards to the allegations that Optimum had a difficult time prior to the new owners, I don't want to talk to that in the sense because I dealt with Optimum in terms of trying to look in terms of that particular agreement. I don't want to also deal with the temporary relief that was granted by Mr. Mabelane. I would rather provide my thinking behind the temporary relief that I provided to them. I provided to them a temporary relief of 3 months, and it was quite specific in terms of the period, because in my understanding is that if you are having difficulty with your operations and you have indicated to the operations team, Eskom operations team, that it will take you the 3 to 4 months to resolve it, that then we are willing to look at that. But you will also note that of the different reliefs that were provided, my relief was linked to in November, where we then instituted, because in my opinion, you had been allowed 3 months to sort out your operations. You were not able to do so. So then we will then begin to institute and take, institute our penalties in terms of your agreement and actually not pay for anything that we get from you. And that was my thinking at the time. It did not mean that because it was now Tegeta, it was simply in terms of trying to get the coal, you're not able to supply us with the coal, we put in penalties, etc. They did complain that they felt it was unfair, but that was the contractual understanding and obligation that I believed served for my temporary relief.
Just to round off on this point, because one may be trying to look at this only to find that maybe the foundation of one's thinking is flawed. You would know whether or not the prices that Eskom paid for coal were dictated, at least in part, maybe wholly, by the quality of the coal that would be supplied. In other words, I know we have been talking about different grades. Do you know whether there was that distinction, or was there no distinction about the, whether the quality was part of what was taken into account in saying we will pay so much for this coal? I would have imagined that
in the later years, the quality was linked to, the price was linked to the quality. And as we moved towards more of a rand per gigajoule contracting, so it was linked to the quality, it was also linked to the market.
Mm-hmm. So, and at the time of you granting this relief, does this fall within those years, or does it not fall within those years, the time when you granted the relief?
It was in the later years, however, the contract was linked to a rand per ton. So the
Yes.
contract was signed, I think, in the 1960s. I stand to be
Yes.
corrected.
Mm-hmm.
So we were operating on an older pricing mechanism within a current period.
Yeah. Okay, Mr. Selega.
Thank you, Chairperson. Dr.
We have not gone on the tea break. We have gone past the tea break. We can take the tea break if somebody feels that they need a tea break. Otherwise, we could take it at 12 o'clock. Dr. Nteta, do you need a tea break right now, or comfort break? Or we can take the break at 12 from your side?
We can take the break at 12, sir.
Mr. Selega?
I'm also fine, Chairperson.
You're fine.
To continue.
Your junior is fine as well.
She
Okay,
takes
all
the
right.
cue from me.
Okay, let's continue. We'll take it at 12.
Thank you. Dr. Nteta, your explanation regarding your own temporary relief that you granted must, of course, be understood against the background of the previous temporary relief, which was given for 10 months. Isn't it?
Yes.
Because, in fact, in your affidavit, what you are saying is you were not giving them a new, well, the essence is you were not giving them a new temporary relief, you were extending the existing temporary relief.
Correct.
So if it was an extension of a 10 months temporary relief, now you're adding 3 months to it, one wonders whether, did you have different reasons at a time when you granted yours that were different from the reasons that were given to Mr. Mabelan 10 months before? I mean, in fact, in December 2016.
So one of the questions that I asked the coal operations team is that what has happened since December to up to this date? Were they not able to resolve their issues that they had, which was their operational issues and in terms of the area that they were mining? And the response that they provided is that they were not able to resolve those areas. They are still mining in that particular area. So there will still be issues in terms of the volume. Now, for those kind of engagements and understanding, I would rely on the people mandated to manage the contract to use their judgment and then say whether it works or not. So, and when you talk about in mining operations, it can take you 3 weeks to mine through an area, it can take you a year to mine through an area.
Yes, but...
So in them saying that it...
Sorry,
Yes.
let me interrupt, because that's a general statement. One always has to confine oneself to this particular request, this particular relief that was granted,
Yes.
the reasons why it was granted, and why you signed for it, instead of making a generalized statement, because it doesn't assist us know the facts of what transpired here.
So specific to this agreement, I asked the coal operations department as to what has changed.
Yes.
Because they had the temporary relief. Have they gone and mined through the area that they need to mine through? And the answer was that no, they have not. They still have challenges on their operations.
So the chairperson has accelerated the matter because it's exactly, I wanted to go exactly to where the chairperson was talking about. That, and I just need to make that statement for you, that prior to Tegeta taking over, the position of Eskom regarding Optimum, after they entered into that cooperation agreement, and they were also doing, as you quite correctly point out, it was a relief. It's a temporary relief in regard to the quality of coal and the volumes. However, when Mr. Molefe comes on board, he terminates that. And there's an insistence on the part of Mr. Molefe and Mr. Koko that we want the penalties to be paid of 2.17 billion. You're aware of that?
Yes.
And that is the stance that was adopted throughout until the mine is taken over by Tegeta. And now we see, after that, there's a different attitude on the part of Eskom. They are willing to compromise on the coal and the volume, the quality and the volume. And for a long period of time, 13 months, shortly before Tegeta is unable to operate and it goes into business rescue. You see the picture that emerges?
Yes.
Yes. So then, I'll move on. Well, just before I do that, the penalties that were imposed, you say in November 2017, were those the only penalties imposed?
Sorry, I didn't hear the question.
The penalties imposed in November 2017, were those the only penalties imposed, to your knowledge, in regard to Tegeta?
I don't know. I'd request that you ask the finance department.
Okay.
As far as I know, it was the only ones, but I'm not sure.
Dr. Nteta, paragraph 2, number 2 of your letter granting temporary relief says that in effect, I think, Eskom reserves its rights on all penalties and not dictate the same. What did that mean?
So, sorry, I can't get to that letter now, but
Page
so
188.
one of the elements in terms of reserving the rights is that though we are providing you with this temporary relief, we reserve the rights to impose our penalties we reserve our rights in terms of the contract so that we can then institute aspects of the contract, which is the clause that I used to then impose the penalties. I said that because we are reserving our rights.
But you remember what you and I got to understand each other on with regard
Yes.
to the place of penalties during a period of temporary relief. This gives one the impression that you, Eskom, would be saying, we are granting you temporary relief, but we reserve the right to impose penalties on you for doing exactly what we have decided to condone. That doesn't seem to make sense to me if that is what it means. Does it mean that, or does it mean something else?
That
In
is
other
my
words,
understanding because it's an open.
Just to make sure you understand what I mean. When I read this, I understand Eskom to be saying, we are granting you temporary relief, which means you can provide us less volumes of coal, you can provide us a lower quality of coal, and that conduct on your part would normally be a breach of the contract. And if you were acting in breach of the contract, we would be entitled to do a number of things, including penalties. Now we are granting you temporary relief. We are saying you may do those things, but at the same time, we are saying we are reserving our rights to impose penalties. Is my understanding of what it says correct?
It is correct, sir, which is why I said earlier that the suppliers would agree with you, because they say that you give us this opportunity, but you have something hanging over our head because you can come back and impose.
Are you saying, therefore, that although this is what is written here, you didn't really intend to do that because it wouldn't make sense to provide temporary relief and still impose penalties?
So the intention was to provide temporary relief, but we wanted to ensure that we reserve our rights. So if for whatever reason that comes out in that period, if something comes up, we want to be able to still institute and impose penalties. So it is a letter that is saying we understand your issues. However, we are keeping the door open for ourselves.
But do you accept that it doesn't make sense? The two can't live together during a period where you have granted temporary relief. Be genuine. If you grant temporary relief genuinely, you can't be, you can't grant with one hand and take away with the other. You accept that?
So you're asking a practitioner, a procurement practitioner. So I'll say I understand it, but I would also want to leave the door open for my company.
No.
So, yes, I hear you.
Yeah, but you understand now that although at that time that's how you thought, But when you,
Yes.
we interrogate it now, you can see where the challenges are with having that clause.
Yes.
Yeah, okay.
Thank you, Chair.
Mr. Selega?
Yeah. And, I mean, yeah, your penalties, the penalties imposed by you, Dr. Nteta, if it is you who imposed the penalties, it's for November.
Maybe, I'm sorry, Mr. Selega, just to make sure we round off on this, at least as far as my issue is concerned, Dr. Nteta. Do you accept, as you testify now, that where you have granted as Eskom, where Eskom had granted temporary relief to a supplier of coal, to in effect say, I'm allowing you to provide me with a lower quality coal for this period. Eskom could not subsequently impose a penalty on a supplier for supplying Eskom with a lower quality in terms of their own temporary relief. Do you accept that it could not do that?
Yes, sir.
Yes. So therefore, where Eskom granted temporary relief, such as the temporary relief that you granted, and I know you said you didn't want to talk about Mr. Mabelane's temporary relief, but this would also apply to his. Then in that case where this temporary relief was granted, by implication, it meant that the supplier would not be visited with penalties for providing Eskom with lower quality coal. You accept that?
Yes.
Okay, all right.
And in fact, Dr. Nteta, it was not for that period.
Pardon?
The supplier was in fact not visited with a penalties for the period of the temporary relief.
Yes. So we did the penalties, I think it was in November.
Yes, after that period, going forward.
For that month, yes.
Yes.
But the penalties that you're talking about, they did not relate, did they, to the period of temporary relief?
So I'd have to look in terms of the actual period, because one of the issues was the volumes, that they had to ensure that they provided a certain volume period. I don't recall the details in particular, but I think that they did not, but I'm not too sure. So it would be to look to those particular requirements in terms of that.
But I think you also said at some stage something to the effect that you imposed those penalties because they did not meet certain conditions that you had imposed for the temporary relief. Is that correct?
Yeah, I would like to have a look in terms of the penalty that was imposed.
Yeah.
If my memory serves me correctly, there was issue, I think, of the volume. So that for 3-month period, and memory, I need to check, they didn't provide the minimum that they were requested to do.
So in other words, what you...
But I would really like to check that.
In other words, insofar as the penalties that you are talking about, that you sought to impose, are concerned, you would be saying, we did not impose penalties in regard to conduct on the part of the supplier that we had condoned. We imposed penalties for conduct that we had not condoned. In other words, if they had said, we will provide 8,000 tons, and you had said, that's fine, you only imposed penalties when they provided less than 8,000. Is that correct?
I think, yes.
That's
Like
your-
I
that
said,
would
I
be
would
your
like to have a
understanding.
look in terms of that. Yeah.
But that would be your
Yes,
understanding?
yeah, I think so.
Yeah, okay, all right.
Yes,
Yes.
yeah.
In other words, they would have breached the relief that was even given. So they went lower than the relief that was even given, and for that they would have attracted penalties, insofar as they even breached the relief that was granted.
Yes, insofar as if they did breach that relief, yes.
So the principle, if your recollection is correct, would be we won't impose penalties as long as you, the supplier, stay within the ambit of the temporary relief. But once you go outside of the ambit of the temporary relief, namely, we have agreed that you may give us 8,000 instead of 10,000, you then give us 6,000, then we will impose penalties because you are now outside of the relief we have granted. But as long as you stay within the four corners of the temporary relief we have given you, there will be no penalties. And as far as quality is concerned, if you continue to give us the quality that we have said is acceptable to us, for example, grade B instead of grade A, there will be no penalties. But if you then begin to give us grade C or grade D, then there will be penalties. Those would be the principles as you understand how you would have applied them.
Yes, and also within that period, we will almost like leave you, but as soon as that period is finished, then
Yes,
it's
you
a
go
different
back.
discussion.
Yeah, okay.
Chair, I want to go to a different topic. I see it's 3 minutes before 12.
Yes, okay. Let's take the tea break then.
Yes.
We take a 15 minutes tea break. We adjourn.
Thank you, Chair.
Dr. Nteta? Dr. Nteta?
Yes, I'm here.
Yes, we are going to resume soon.
Thank you.
All rise.
Let's continue. I see we were not able to keep within the 2 hours that we had agreed upon, but that's not your fault, Mr. Selega.
Yeah.
I had lots of questions for Dr. Nteta, which took some time.
It's not yet up, Chair. We still have some time.
Well, we started at 12:30, so the 2 hours will be up at 12:30. We started 10:30.
Yeah.
After the technical
The
issues that
technical
happened.
issue.
So I don't think you will finish within 15 minutes. But let's continue.
Yes.
The bottom line is that while we want to finish as early as soon as possible, we don't want to leave issues not dealt with properly. We seek to strike a balance between not being too slow and taking a lot of time, but at the same time being able to do justice to the issues.
Yes.
Okay, all right.
Thank you, Chair. Dr. Nteta, I want to move on to a different aspect, which is your second meeting with Mr. Tony Gupta. Now, that's the meeting that comes after the contract with Tegeta in regard to Brockfontein has been concluded on the 10th of March 2015. You had the first meeting. Subsequent to that, you can't recall exactly when. And then you also talk about the second meeting. As I go into that second meeting, I have a question in regard to the address of Tegeta's premises or offices, Tegeta. The address...
I'm sorry, Mr. Selega, I missed some of the things you said earlier on.
Yes, Chair.
Are you saying you're going to a second meeting she had with Tegeta or at Saxon Way?
With Mr. Tony Gupta.
With Mr. Tony Gupta.
Yes.
Okay, all right. Okay.
But there was just something I needed to clarify with her in regard to the first meeting because of the address. I understand, Ms. Nteta, that Dr. Nteta, the Tegeta's offices are in Senton, eh? The address is in Senton.
Yes.
And is it correct that you would have known that address during the time of engagement with them prior to them being given the contract or awarded the contract?
No.
From your communication with them?
So
by email?
I did. The communication that I had with them was basically via email or on the phone or in person.
Yes. Okay. Now let's go into the second meeting. Could you please tell the chairperson how that meeting came about and what was discussed?
And when it was?
Okay. In terms of when it was, I cannot recall the exact date, but with regards to how it came about, Mr. Tony Gupta called me on my cell phone.
I'm sorry. You can't recall the
Yes.
exact date, but would you recall the year and the month, more or less? Which year was it? You can't remember that either.
What I can say, it was, I can't remember. It would have been after the contract was signed, which was from March 2015, but I can't recall
Okay, no, that's fine. That's
exactly when.
fine. Okay, all right, continue.
So Mr. Tony Gupta gave me a call and requested that he would like to meet with me. I indicated I would meet with him, and the reason why I opted to meet with him is because we had been engaging with the CEO, who is Mr. Ravindra Nath, with regards to the current coal supply agreement that Tegeta had with Eskom. Myself, and I don't believe I was alone in that, felt that that coal supply agreement, frankly put, was badly written. There were grammatical errors within it, and we in terms of fuel sourcing, had been looking to clean it up and just improve it. Also, what I had been working on with the team was a master coal supply agreement, which is a standard template. So also wanting to move it into our standard master supply agreement template. So the team, I had requested the team to engage with Mr. Ravindra Nath, the CEO, on several occasions, and they were not getting any traction in terms of that agreement. And in fact, there was almost of a stubborn not moving, where he would agree to meet, he would be given the agenda, he would then get to the meeting, they would discuss issues, he would say, okay, he'll attend to it, and then he would not. And this had been going on actually for for a while, for some months. So when Mr. Tony Gupta requested for the meeting, I had thought to assist the team in being able to unblock, because I felt that Mr. Nath was being instructed actually not to engage with us and not to do anything with the contract. So I was hopeful, or I can say rather ambitious, in wanting to then address it with their shareholder to request Mr. Tony Gupta to actually instruct his CEO to engage with us so that we can then start to access the contract and move it towards the master supply agreement. So upon arrival at the residence,
just before you move on, Dr. Nteta,
Yeah.
just before you move on, you say Mr. Tony Gupta called you, telephoned you.
Yes.
So would you have given him your contact details?
No.
So how was he able to telephone you?
I will assume he would have received the number maybe from Mr. Nath. I cannot answer where he got my number from.
Could you have exchanged your details with him in your first meeting? Could you have?
No. No.
When he telephoned you, did he tell you the reason for asking to meet with you?
So when he called me, he indicated he'd like to talk to me with regards to the coal supply agreement.
Yes, but what about it?
He just said, I'd like to talk to you about the coal supply agreement. I will be quite frank and say, when I received the call, it was, for me, I thought, great, now we can talk about this coal supply agreement, and then I can request that he asks his CEO to engage with the negotiations.
If he didn't tell you the details, just mention coal supply agreement, did you ask him what about the coal supply agreement so that you can prepare yourself for the meeting?
No, I did not do so, because one, what was forefront in my mind at the time was the difficulty we were having with the CEO. So when I received the call, what came to my mind immediately was the opportunity to have him speak to his CEO, because we were not getting any traction.
By this time, which is either in middle 2015 or later 2015, did you now, after your first meeting, have knowledge of who Mr. Tony Gupta was?
I had knowledge of who he was after the first meeting, correct?
Did you tell your immediate director at Eskom that I was called into this meeting, and lo and behold, thinking that I was going to meet with Mr. Nath, it was Mr. Tony Gupta meeting with me?
So I did not inform my directors, my immediate bosses with regards to that. And quite frankly, because the environment within Eskom was not one of great trust, comfort, so I did not.
I see. Did you tell anybody, because you mentioned to him in the first meeting, that what he wants, information that he wants, or yes, falls within the primary energy division? Did you tell anybody within that division that there is this inquiry by Mr. Tony Gupta?
So I informed I informed the coal operations team with regards to that there seems to be a requirement or a query with regards to the management and operations of that. So they should expect a discussion with Mr. Nath, because at my first meeting I indicated to Mr. Gupta that through his CEO, he should engage the coal operations people.
Okay. But you didn't mention to the division that you had a meeting with Mr. Tony Gupta?
No, I did not.
Okay. Back to the second meeting, you can't remember when, but do you drive again to Saxon World?
Yes, I do.
Just before that, I may have missed something, Dr. Nteta. The difficulties to which you have alluded, that you say you had or Eskom had with the CEO, is that the CEO of Tegeta?
Yes, it's with the CEO of Tegeta,
And who was the CEO of Tegeta at the time?
Mr. Ravi Nath.
Yes. What were those difficulties?
So the difficulties that we were having was in regards to him engaging with us on discussing and moving the current contract that was signed with them, moving it towards our master coal supply agreement template. And in cleaning up the grammatical issues that were there in the agreement. So he would.
So there was an agreement
Yes, sir.
that was in place already between Eskom and them.
There was an agreement.
Yes.
Yes.
But there were concerns that you as Eskom had about the agreement. Is that correct?
Yes, the quality of the agreement.
The quality of the agreement. And you wanted
Yes.
Tegeta and Eskom to actually adopt another agreement. I think you call it master coal agreement or something like that.
Yes. So we wanted to move it to the master coal supply agreement template that we had been engaging with legal on, and we wanted to use it as a template going forward for all our suppliers. And also there were grammatical issues, mistakes in the agreement. So it was to clean it up.
Yes, okay. And he was he reluctant to do so, or was it just taking long to do what he needed to do for the two parties to get to the master agreement?
He was reluctant.
He was reluctant, and that's where your issues were with him.
Yes.
Okay, all right. But from what you are saying, in substance, there might not have been a problem with the agreement that was in place then, but it was simply not the Eskom template agreement, and maybe because of grammatical mistakes and so on, it was a little embarrassing to Eskom.
So yes, there was no issue in terms of generally let me not say that. One of the elements that came out, there was a price PwC audit that was done on a few suppliers within the primary energy space. And one of the things that the PwC audit came up with was in terms of the agreement, the quality of the agreement, and their recommendation had been that we need to improve it, and we need to move it towards, we need to improve it. And for me, the suggestion was to move it towards the master template that I've been working on.
I would imagine that Eskom would have maybe a template, would have a precedent, an agreement to say whenever we are going to conclude a coal agreement with a supplier, this is the type of agreement we conclude. And that most of the time, the supplier would fit in within the terms of that standard agreement. Obviously, there may be changes here and there, but most of the time, the supplier would accept the agreement that Eskom normally uses to conclude coal arrangements. Would that be correct?
Your thinking is correct. However, there was no, excuse me. Excuse me.
You want to drink water?
I think I'm fine now. I muted to clear my throat.
All right.
So, your thinking is correct in the sense that there should be a standard template that, particularly in the environment, well, a standard template that can be used for, if I use it as coal supply agreement. However, there was no specific template. And what the practice and what would happen is that we would then indicate to legal that we need an agreement in place for the supply of coal. These are the details in terms of the supplier, etc. And we would engage, and they would engage and draft individual agreements per supplier. Whether they in the background had some form of template that they would have used in general, they would then
You don't know.
you would have to ask them.
Yes.
So what I had said, because one of the issues is that it would take a lot of time and there'd be a lot of backwards and forth. So I had started working with the legal department to come up with that very template, that we have standard clauses that if there are deviations, we get approval from legal for the deviations.
And this particular agreement with which you were not so happy, had it been prepared by Eskom's legal department, or had it been prepared by Tegeta or their lawyers?
Eskom legal department.
Oh. What had happened? They had always been preparing these agreements, and I assume the quality was fine. What happened this time? Do you know? Or you also don't know what had happened?
I don't know what has happened. I've had the opportunity last night to read Mr. Bester's
Affidavit.
affidavit. And in Mr. Bester's affidavit, he indicates that he was instructed to get an agreement in place within 48 hours. So I can only deduce, based on Mr. Bester's affidavit, that that is why the quality was not
Yes, was not what
to
it
my
should
standard.
be. Yeah. Okay, I'm sorry. I interrupted. I just wanted to understand why you were welcoming the second meeting, a proposal for a second meeting with Mr. Tony Gupta. So I wanted to understand that.
Yes.
But back to the conversation where Mr. Tony Gupta
Chair.
called you.
May I ask something before
Yes,
you
okay.
move on, because it's important for, yes. If, Dr. Nteta, if you turn to page 66, paragraph 6.7, just before the chairperson moves on to a different point. Paragraph 6.7. in the light of the answers that you have given to the chairperson regarding a template, how should we understand that paragraph that on 7 November 2014, this is before March 2015 when the agreement was concluded, you say, you sent an email to Mr. Nath of Tegeta attaching co-supply agreement template for their perusal. This is a normal occurrence, particularly for new suppliers
Yes.
that have never contracted with Eskom. So there seems to be
So what
a template.
I sent through to Mr. Nath, as I indicated to you, each engagement that we have with the supplier, we go to legal and we then indicate to them, we want to have an agreement with them, and they would then draft a CSA template or CSA agreement, and then it would then get sent. But at the time there was no, and perhaps it is just my thinking, there was no signed off co-supply agreement that had standard clauses that day or night, whoever we are dealing with, these are the standard clauses that we always use. The legal department would send us a co-supply template. Sometimes we would simply delete from a previous one, we would delete the supplier name and send it. But there was nothing that was, for what I believe should be correct, is a signed off template.
Yes, that may well be so, but I think
So what I sent to him was something that I had received from legal, because I'd indicated to them that we would be talking to the supplier, and it's something that is an agreement which would have been used for another coal supply agreement.
yeah. But the entire paragraph of your affidavit, 6.7, conveys the message that this was your standard practice or normal practice, as you use the word, in regard to new suppliers. So a template was there, whether it's signed off or not, but there is this template that you would share with the new supplier prior to the agreement being concluded, so that you give them the opportunity to familiarize themselves with what would be the terms of the agreement, to raise concerns if they so wish, and discuss the matter with you.
Correct. So when I say this was standard in terms of new suppliers, so when I say with standard, if a new supplier is engaging with the organization, they have no sight of the type of agreements that are in place.
Yes.
So what we try and do is provide them an example of the type of agreements in place.
Yes, and this is the point.
And that is what I say, that standard. Yes.
Yes, and this is the point.
So,
Carry on.
exactly. So when, sorry, yes, sir.
You can go ahead.
So the issue and the concern that I'm trying to raise here is that even though we send them the type of agreements in place, when we engage with legal, they then draft and it, one against the other is not necessarily all the time that it is the same. It would depend on who within the legal department is drafting the agreement, who within the legal department I would be working with as opposed to my colleague, and they would then provide an agreement. But there is nothing that is, what I was looking for is something that would come and be signed off by the head of legal, that this is what we should always send through, because, yes.
Yeah, but the point is this, that prior to the contract being signed on the 10th of March 2015, the supplier, potential supplier, had been given the template of a contract about 4 months before,
Yes.
which template you would have seen, You created an email
Yes.
attaching the template and sending it to the supplier. It is surprising that after such a long period of time, prior to concluding the contract, once it is concluded with mistakes that needed to be amended or improved.
In other words, why didn't you correct the
Yes, it is
mistakes before
surprising.
you signed? In other words, why didn't you as Eskom correct the mistakes before you signed?
So I sent the agreement 4 months earlier, as indicated by Advocate Silika. And that is where it is. Now, when the 48 hours before that Mr. Bester refers to, what would have happened is that they would, when I say they, legal would have sent an agreement because there would have been a request, can you send the agreement? And then that agreement gets sent again. It does not necessarily mean the same agreement that was sent 4 months ago is the same agreement that we get sent later, because there is no generic signed off template. So the question is, why would it not be corrected or not been fixed before it was signed? I am going to then deduce from the information from Mr. Bester, the 48 hours is that there was a rush to sign that particular agreement, and the legal department did not thoroughly go through the agreement, because the element of the agreement would be something that it's within the domain of legal, and I don't want to answer that particular aspect. So what I observed after the fact is that there are grammatical issues in it. And whilst there are grammatical issues, let us move to what the journey that we are taking to go to a master co-supply agreement template that is signed off by legal.
Do you know what the grounds of urgency were that justified imposing this 48-hour period within which it had been signed? And from what you are saying, it looks like that imposition, that period might not have been imposed by Eskom. Maybe it was imposed by Tegeta. Do you know what the reasons were given why it had to be rushed like this in circumstances where 4 months earlier, or even 5 months earlier, you had sent a template to Tegeta? There had been ample time for both sides to look at the agreement, correct whatever mistakes, and sign it. Do you know what reasons were given for this 48 hours ultimatum? No,
I don't know, because I wasn't given the reasons. As I indicated, as I had the opportunity to look at Mr. Bester's affidavit, that is where I then see that it was, he was requested within 48 hours.
Yes. Okay, all right. Mr. Silega?
Yeah, take us then, Dr. Nteta, into your second meeting.
Before the second meeting, let's go to the conversation arranging the second meeting.
Yes.
Did
So as
the
I
two of
indicated,
you-
he gave me a...
Did the two of you agree what the venue would be for your meeting? That is Tony Gupta and yourself.
Yes, so he requested that I come through to Saximat and to discuss the co-supply, to discuss the co-supply agreement.
And you agreed.
Yes. And I agreed.
Why did you agree to go to him rather than him coming to you?
The reason why I agreed to go to him.
You had already been there before in terms of the first meeting. I would normally have expected that a supplier who wants to have an agreement with Eskom comes to Eskom, generally. But I will allow for the fact that there may be circumstances where you might say, let's meet at a neutral venue, maybe even let's meet at the supplier's place. But I would have normally expected that Eskom would say, you come to us, you know. But here, you had already been there first time. Why do you agree to go to the venue to be their venue second time around?
I concede with you that we normally would meet suppliers at Eskom. We would sometimes meet suppliers at a neutral venue, at the financiers, etc. We do that. And I also concede to you, it is not best practice that to do so. At the time, I was just hoping that I would be able to resolve a matter and unblock, and which is why I agreed. But I will concede that generally we should be meeting at Eskom only.
Mr. Selega?
I thought the chairperson might also be interested in this. When I asked Dr. Nteta whether you mentioned to anyone, particularly your immediate superiors at Eskom, that you had a meeting with Mr. Tony Gupta the first time around, you said no, you didn't, because of issues of trust. You think you can elaborate on that?
Yes, I can. So in the lead up to the initial agreement, if you, the Brakfontein agreement,
Yes.
I had been engaging with the supplier for about, I don't know, about 12, 18 months prior to that. From the time of about January 2015, when my immediate supervisor joined us for the meeting with Tegeta. From that time, from January 2018 to, I'll say, until about March, there was continued requests that from the senior general manager for me to be providing weekly reports with regards to the progress on the transactions, etc. And for me, it built a level of lack of trust or lack of understanding of the genuineness of the engagement. And I, at the time when I was meeting, I did not know that if I then go and let's say complain or inform my superiors that I've had this meeting or I'm trying to for whatever reason, I did not feel that they would then support me, and it might be detrimental to myself and my job.
Okay, I'm not sure that I follow that. Yeah. As I understand it, Mr. Selega's question was whether you shared with the information with anybody that you were going to have a meeting with Mr. Tony Gupta. The second meeting, is that correct, Mr. Selega?
That she had the first meeting with him.
Yes, yes. So your answer is yes, you did not tell anybody.
No.
Is that right?
Yes.
And you say the reason why you didn't tell anybody was because the environment at Eskom at that time was such that you did not trust. What did you not trust? That's what I want to get.
I did not trust the people that I worked with at Eskom.
Mm-hmm.
I did not trust that I would get the support for what I would want to do at Eskom. That is the trust that I did not have.
Well, the one person one could expect you to share the information with would have been your immediate boss, is that correct?
Correct.
And at that time, who was that?
My immediate boss at that time was Mr. Mboweni.
Mr. Mboweni. You say you did not trust that they could support you. What kind of support are you talking about? You were going to have a
So-
meeting with Mr. Nath. That is the first meeting, which ended up being with Mr. Tony Gupta. What support are you talking about that you thought they would not give you?
So my immediate boss was Mr. Mboweni. Prior to when we were signing the agreement, he had requested that I provide him with weekly reports. I did not understand where, why, and where those reports were going and why. So I was not feeling comfortable. I did not know, quite frankly, where he stands. So in answering you in terms of the person you should have told immediately would be Mr. Mboweni. I was not comfortable in understanding what would happen to me and sharing with him the information. The kind of support that I'm also talking about. So for the second meeting, we from the fuel sourcing division, we're wanting to open the contract and engage with the contract. And the supplier was not moved. So I did not know as to whether there would be support for us to fix that contract, or they would then say, leave it alone. And I just felt that it needed to move to a master supply agreement.
Did you believe that there was a risk that if you shared this information with Mr. Mboweni, he could ask you not to pursue the line that you wanted to pursue about the contract, or did you believe that he might give information to Tegeta that you didn't want to be given to Tegeta except through yourself at the right time, or both?
I would say it would be both, in terms of just a lack of general trust and comfort. I also believe that I could potentially lose my job, and they could look for something, or for reason to do so. So it was not a pleasant environment in which to work on, and there was fear.
What is it that you thought they would fire you for?
Sir, I don't know what they would fire me for, but just judging in terms of the corporate environment, they can be anything that they can look for something. So I cannot say I felt it was X or Y, but I just felt that it is not something they would then decide to make my time there very unpleasant or find reason to fire me.
Did you believe at the time that Mr. Mboweni was in one way or another on the side of Tegeta or the Guptas on certain issues between Eskom and Tegeta?
I did not know. At the time, I did not know.
See, I'm trying to understand your reasons for not sharing the information with him and the issue of the absence of trust that you have talked about, that you did not trust him. Because if you told him that you had just been to a meeting with Tony Gupta and this is what happened, you thought you had an arrangement to meet with Mr. Nath, and this is what happened. I don't see on the face of that anything that should make you think if you shared that information with him, you could be fired. So that's why I'm trying to understand, why would you think along the lines of losing your job if you simply shared the information with him that you had been to a meeting with Mr. Tony Gupta and this is what happened?
The reason why I would feel that way, as I indicated before, he had been requesting me earlier to give him weekly reports. What face value would be that why does somebody need weekly reports? Where is it going? Why is it going? And if it is not something that should be requested, why is he not in a position to indicate to whoever is requesting those reports that they will not be forthcoming? So I did not feel that even in his position, he was able to resist any pressures that he was getting. And what would happen is that instead of protecting myself or people within the division, what would simply happen is that then we would then be, I'm going to use a strong word, persecuted. So the environment, though it is, what I'm trying to share with you is that it was not pleasant, it was toxic, and there was lack of trust within the organization. So whether it's my immediate supervisor or someone with people within above him, there was a lack of trust in terms of that I had.
Did you think that Mr.
So sharing with him, sorry, yes, sir?
Yes, continue.
So sharing with him in terms of meeting with them and you know, the irritation that I felt, I did not feel that it's something that would remain between the two of us, and it was a safe environment.
So, are you saying that what you didn't want to share with him is the fact that you were irritated by what had happened, but it would not be the mere sharing of information that you had had a meeting with Tony Gupta that you had a problem with? In other words, the part you did not want to share with him is that you were irritated.
No, the part that I did not want to share with was one, that I was irritated. Two, that I had had a meeting with Mr. Gupta. Three, it was, you know, under the guise of meeting with the supplier. I did not want to share with him because I did not know the implications. At the time, I did not know if he was aware of it. I did not know if he was aware that they were going to ask for it. I did not know, because we did not know where information was going, what was the consequences of it, etc. So that is why I did not feel safe.
Did you think that he would not have liked the idea of you having met with Mr. Tony Gupta?
I don't know. I don't know whether if he would not have liked it or he would have been upset that within 15 minutes I left. You know, I don't know. I did not know where he stood. I was uncomfortable about it. And yes, so I did not know whether, even if he was aware and I did not know, but I did not feel comfortable and I did not feel safe.
But how would you report to him, seeing that he was your immediate boss? How would you report to him on progress about this matter if you were not going to tell him that you had had a meeting with Mr. Tony Gupta? How could your report to him be a reasonable one or accurate one if you are going to not tell him about such a meeting?
So I would report to him in terms of the progress on various transactions. it is not, the reporting to him on the transactions is not, it was not regular meetings where I would run him through various transactions, because we dealt with quite a few transactions. So it's not, the repertoire that we had was not a regular, one-on-one meetings, just quite purely because of the sheer volume of his responsibility.
Did he know that you were uncomfortable with the existing agreement and that you wanted the parties to move to what you called, I think, master coal agreement? Did he know that you had that problem with the existing agreement? Did you share that with him?
I don't know. I can't recall if he knew, but he may have known, because as I indicated to you, PwC provided a report on it. So I can't answer. I can't answer if he knew at the time.
If he did know, do you know whether he would have known because you told him, or he might have known from other sources?
So he might, like I've indicated, he might have known, because the PwC report would have been sent to him. So through reading it, he would have then picked up that the agreement needs to be improved. I don't recall having a discussion with him specifically on that. I don't recall, but I know that the report was sent to him. I cannot answer to you whether he read the report or not.
Okay, Mr. Selega, I know I interrupted you. We are at 3 minutes, 4 minutes past 1. Yes. But if there are 2 or 3 questions that you think should not wait for after lunch, you can deal with them. But if you are fine, we could adjourn at this stage.
I'm fine, Chairperson. It will be the next issue.
Yeah.
Yeah, so...
or maybe should we try, if we can, and finish with the content of the second meeting? Or will that, how long do you
Can
think
we
that
do
would
that?
take?
Yes, I would accept that proposal, Chair.
Yeah, let's do that. Yeah.
Yes. Dr. Nteta, just before we go on a break, just go into the second meeting then, and what gets to be discussed in that meeting?
So what gets to be discussed is that one of the issues that Mr. Gupta asked me about was looking at he was interested in the difference between what we call medium-term coal supply agreements, for which Tegeta falls within, and also interested in terms of cost-plus agreements, cost-plus contracts, which is where the traditional agreements that were signed in about 1960s. So he was interested to understand what are the differences between the two, who gets a cost supply agreement, who gets a medium-term supply agreement, why do we no longer provide cost-plus agreements. So those are the contents of the discussion that we had. Yeah. Also, the content of the discussion is that I raised with him, I said, speaking of your medium-term agreement, we would like to move it to a template, and we feel that your CEO is not engaging us on it, and requesting that he instruct his CEO to engage with us on it.
Yes. Okay.
That is the content of the discussion.
Yeah. You give us some of that content on page 83 of Eskom Bundle 14, paragraph 9.6. What I picked up as you go there, between the first and the second meeting, is that, which is one thing you've left out in your explanation, There is one commonality there, the sampling process. Coal sampling. It was discussed in the first meeting. It's also discussed in this meeting.
Yes. So in the discussion, in looking in terms of the two, the coal sampling that happens more on the cost plus agreements is because those mines have a conveyor directly to the power station that they are feeding. So the sampling process is different because there's not necessarily stockpiles. Whereas in the medium-term agreement, the coal is mined, it is placed on a stockpile, and then it's sampled, and the samples are taken to labs, etc. So, so those are the differences in terms of the two agreements. So when I was saying, was asking in terms of what are the differences, etc., and also looking in terms of why is the case that on the cost plus they don't have stockpiles, etc.
But doesn't this discussion make you uncomfortable?
The discussion about the cost plus elements.
No, what Mr. Tony
The discussion
Gupta,
in general.
Yes, what Mr. Tony Gupta is seeking to discuss with you, doesn't it make you uncomfortable?
It makes me uncomfortable and it raises concern.
Yes.
It raised a concern to me in terms of also upon leaving, because it was also a very short meeting, was because I then said to myself, I was wondering if they were looking to move towards a cost plus arrangement because they are currently in a medium-term agreement. So I made a note to myself that, be prepared that if they then do decide to open this agreement, because I was hopeful that they would, that they might want to then change the agreement in totality and move it towards a cost plus agreement because of asking in terms of how those mechanisms work.
Yes, but the point I'm making with you is this. You said one of the reasons why you didn't tell your immediate boss is that you don't know
Yes.
what he might say about you meeting with a supplier.
Yes.
And that's where my focus is. That here you are,
Yes.
an employee of Eskom, you go out of your office. This is not a weekend on a Saturday, you mind your business. You are on duty. And you come being called
Yes.
from your office, you go to the man at his private residence to discuss matters of your work.
Yes.
That's my question. Doesn't
Yes.
that make you uncomfortable? Isn't that something that you, in fact, could have been disciplined about?
I cannot answer as to whether it could have been disciplined about with regards to that, because in terms of meeting with suppliers, leaving our place of work, that is something that does happen. I indicated at the beginning of this discussion to the chair that I concede that it is not best practice to go and meet a supplier outside of the organization. I concede to that fact.
Okay.
Whether it was done and in terms of a practice at Eskom, it is, because not only myself, but even our seniors meet suppliers outside of the premises of Eskom. And it's not best practice. Making me feel uncomfortable, yes, I did feel uncomfortable. One of the elements that I was also uncomfortable about is that where did he learn about cost plus agreements?
Yes.
So, and how much information does he know? Is he verifying this? So those are the kind of things. And I just said to myself, the team needs to be wary that if they are going to open this agreement, that might be something that comes up.
Yes. Well, do you agree that the fact that you did not share with, or maybe let me ask this question first. We know that you didn't share with anybody within Eskom the fact of your first meeting with Mr. Tony Gupta, is that right?
Yes,
Yeah, at least not with
I-
your immediate boss. At least not with your
Yes,
immediate
not-
boss, yes, yeah.
yes, yes.
Is that what happened also in regard to the second meeting with Mr. Gupta? Did you also not share
Yes.
it with your immediate boss?
Yes, I did not share with my immediate boss.
Did you share it with other people within Eskom?
No, I did not share with anyone within Eskom.
Yes.
I did not share with my immediate boss.
Yes.
But I did not share with anybody, period.
Yes. Would you not concede that therefore it makes your two meetings with Mr. Tony, this makes your two meetings with Mr. Tony Gupta to really be secret meetings within the context of Eskom? You didn't want anybody within Eskom to know about these two meetings you had with Mr. Tony Gupta. So you kept them as a secret to yourself. What do you say to that?
Yes, I concede that I did not tell anyone at Eskom
Yes.
that I met with him.
Yes.
And I kept it to myself.
Yes.
Correct. I did not feel comfortable and I did not trust.
Yes. Okay, maybe we should adjourn at this stage. We'll adjourn at this stage, Dr. Nteta. It's about 12 minutes past 1. We will resume at 2:15. We adjourn.
It's a lunch adjournment, Dr. Nteta.
Okay, thank you.
You can make your way by 12 minutes past 2 or 10 past 2.
Will do.
Thank you.
Thank you.